Welcome, everybody, to our chair chat today. My name is Mark Schickman. I am a former chair of the section of Civil Rights and Social Justice of the American Bar Association. Chair Chat is a program of our section on civil rights and social justice designed to explore the most important issues of our day and determine what actions or policies we might be taking in order to achieve the result that we want of a society which is emblemized by civil rights and social justice. Today, I am extremely happy to have with us Erwin Chemerinsky as our guest speaker today. Erwin became the 13th dean of Berkeley Law School in 2017. For 10 years before that, he was the founding dean and distinguished professor of law at the University of California, Irvine. Prior to that, he had many other prestigious academic posts, including the Alston and Byrd Professor of Law and Political Science at Duke University. He's a friend of our section, a frequent contributor to the ABA Journal. He's the author of 19 books, last time I counted, including leading case books and treatises about constitutional law. His constitutional law text, I think, is in its 7th edition right now. National Jurist magazine names him as the most influential person in legal education in the United States. In 2022, he was president of the Association of American Law Schools. I can't think of anybody who would be better to speak to us today than Erwin Chemerinsky. Thank you so much for being with us.
Thank you for the kind introduction, and thank you for having me.
Great, thanks. So there's a couple of topics I'd kind of like to get into with you, and I'm sure that our audience would like to hear about. We are the section of civil rights and social justice, and a lot of us have the view that we have had a liberal Supreme Court that has enshrined all these constitutional rights from Miranda to Roe, and that there is a retrenchment at this point. How do you see that? Can you describe to us your view of the Supreme Court and where it's been and where it's turning?
The Warren Court was from 1953 to 1969. It was the only time in American history where there's a liberal majority on the court. That changed in 1969 when Chief Justice Warren Burger and Justice Harry Blackmun replaced Chief Justice Earl Warren and Justice Abe Fortas. And over the decades since, the court's become increasingly more conservative. If you look at the first part of the last decade, you had the Supreme Court decide Citizens United versus Federal Election Commission. You had the Supreme Court decide Shelby County versus Holder that gutted the Voting Rights Act. And I can give many more examples of the court being conservative. But there is no doubt that the 3 Trump appointees to the court have made it, by every measure, the most conservative court that we've had since the 1930s. If I can, just think about what's gone on in the last 2 years in the Supreme Court. The court's overruled Roe versus Wade. The court's dramatically expanded gun rights. The court said for the first time that a high school teacher has a First Amendment right to pray at public school events. The court's imposed significant new limits on the power of administrative agencies. The court's effectively overruled 45 years of precedents that allowed college universities to engage in affirmative action. And the court for the first time has said that a business has the right under the First Amendment to discriminate in violation of state anti-discrimination law if the business engaged in expressive activity.
And where do you see the court going from this point? Do you have a prognosis about it?
Remember, there are 6 conservative justices, and they thus have a solid majority to move the law further to the right. I think we're going to see it this term with regard to the court imposing significant new limits on the power of administrative agencies beyond even what they've done for the last couple of years. I think it's a court that's going to, for example, in a high-profile case argued on April 22nd, saying that cities can make it a crime for a person to sleep in public, even if they're housed and have no place else to sleep. And I think this is a court that's going to move the law steadily, sometimes quickly, but in a consistently conservative direction.
So, a liberal value that I've kind of grown up with is independence of the judiciary and giving great deference to the court. What we're seeing today from both sides of the political spectrum, I think, are attacks on the court and discussions of making structural changes in it. Senator Elizabeth Warren says that the court has lost all legitimacy. You hear about thoughts that we should pack the court in order to change its direction or impose term limits or age limits. Do you think that any of those structural answers are a good thing for the court?
I think term limits would be a very good thing on the court. The framers in 1787 couldn't have imagined the life expectancy of the 21st century. In 1787, average life expectancy was 36 years old. I think that the problem with life tenure for Supreme Court justices is that we have justices who are sitting for such very long periods of time now. Clarence Thomas was appointed in 1991 when he was 43 years old. If he remains on the court until he's 90, the age Justice Stevens retired, Thomas will be a justice for 47 years. Amy Coney Barrett was 48 when she was appointed to replace Justice Ruth Bader Ginsburg. If she stays till she's 87, the age at which Justice Ginsburg left the bench, Barrett will be a justice until the year 2059. This is too much power in one person's hands for too long a period of time. I can give you an interesting statistic. From 1787 to 1970, the average tenure of a Supreme Court justice was 15 years, and it stayed remarkably constant over time. For the justices who've been appointed since 1970 and have left the bench, their average tenure is 27 years, and that's a number that's growing. Also, too much depends on the accident history of when there's a vacancy. Jimmy Carter got to pick no justices in his 4 years as president. Richard Nixon picked 4 in his first 2 years as president. Donald Trump picked 3 justices in 4 years, but Jimmy Carter, Bill Clinton, and Barack Obama served a combined 20 years in the White House, and they got to pick only 4 justices.
So, Stephen Breyer has been on the speaking tour recently with a book he's promoting, and his position is the whole time he's been on the court, he never thought about politics, and that once somebody gets appointed to the court, they kind of forget the political allegiances they had before, the party that appointed them. Do you think that Justice Breyer is being Pollyannish about that? Is he an outlier?
Do you mean politics or do you mean ideology? In terms of politics, the Supreme Court justices aren't lobbied like other politicians. The Supreme Court justices don't trade votes, as far as we know, like other politicians. The Supreme Court justices probably don't consciously think about the Republican or Democratic label of the administration or the litigants. But if you mean ideological, then Justice Breyer is just wrong and he knows it, because the Supreme Court's decisions in the high-profile cases are always based on the ideology of the justices. Marbury versus Madison wouldn't have come out the way it did, but for the ideology of John Marshall. The decisions from 1890s and 1936 that struck down 200 federal, state, and local laws protecting workers and consumers wouldn't have come out that way except for the conservative justices. The Warren Court decisions wouldn't have come out in the liberal direction but for the justices. And if not for the 3 Trump picks, if Hillary Clinton had picked those 3 justices, Roe versus Wade wouldn't have been overruled, gun rights wouldn't have been expanded, the affirmative action decisions wouldn't have been overturned.
Wow, thank you. So should we be concerned that this court is gonna be eroding civil rights as it moves on?
Yes, it's already done so. On June 24th, 2022, it overruled Roe versus Wade. It's a decision that's terribly unpopular. The methodology that it set out, following originalism, could put many other rights in danger that aren't enumerated in the Constitution, whether it's the right to purchase and use contraceptives or the right to same-sex marriage. At a time when our country is so deeply politically divided, and it's more divided than it's been since Reconstruction, what will it mean to have a court that's come down so clearly and so far to the right on one side of the divide? That's the key question for the future.
Since you raised the term of the polarization that's taking place in the United States right now, let me ask you about some degrees of polarization that is hitting the news as we speak. And one thing that's striking, Erwin, is any topic I think about raising with you, it seems like you have written a book on the subject. So, a very prolific scholar. One of your books is called Free Speech on Campus. And you had the foresight to write this and publish it in 2017. So let's ask, in terms of the demonstrations that we are seeing on campus right now, is it easy to differentiate between what is protected free speech and what are items that campuses can and should be restricting?
There are instances where it's easy to draw the line, and then there are instances where line drawing is difficult. All ideas and views can be expressed on a college campus, period. Even very offensive ideas and views can be expressed on a college campus. But free speech isn't absolute. If speech rises to the level of incitement or true threats, then it can be punished. There can be time, place, and manner restrictions with regard to speech if they serve an important interest and leave open adequate alternative places for communication. And we could go through a series of examples, and for some it would be easy to say, that's going to be resolved in the following way, no doubt about it. And for others, we'd say, that's a hard question. It's not clear what would happen.
Now, are there, first of all, is there a distinction between what a private school can do with its campuses and what a public university has to deal with?
Absolutely. A public university has to comply with the First Amendment. A private university does not have to comply with the First Amendment. Now, it's a little bit overly simplistic. California, for example, has a statute, the Leonard Law, that says that a private university or school cannot punish speech that a public university cannot punish because of the First Amendment. Schools have faculty and student handbooks. They usually make promises of freedom of speech and academic freedom. Courts have said that those handbooks constitute a contract with the faculty and students, respectively. But the general answer is First Amendment applies to government institutions. It doesn't apply to private institutions.
So talk about a couple of examples. I think that my alma mater, Columbia, has been in the news a little bit yesterday. So when encampments are set up against school rules, an administrative and classroom building is taken over and blockaded. Any doubt as to whether administrations can, and I guess maybe tougher should, be dealing with those kinds of issues in a disciplinary manner?
You draw the right distinction between what they can do and what they should do. They can have time, place, and manner restrictions that prevent disruption of campus activities, so long as there's some place for the demonstrators to go. So a campus can say, you can't have demonstrations near classroom buildings when classes are in session. A campus can say you can't have demonstrations near dormitories in evening and nighttime. A campus can say you can't have encampments or tents in the public area of the campus. All of that is constitutional. All of that is permissible. time, place, and manner restrictions. On the other hand, what they should do is a much harder question. I mean, Colombia has certainly faced this. Colombia had the right under the Constitution to clear out the demonstrators, both when they initially did so and then when they've done so more recently from a building. Should they call the police out in those circumstances? Should they expel students? That's a much harder question. And I'm much more comfortable talking about, I can tell you the law of the First Amendment, but what campus president should do in that circumstance, I'm not sure.
So, and I don't know whether this becomes a closer question. So we had instances both at the UCLA campus and on Columbia where there were protesters who were linking arms, and when they saw a student, maybe wearing a yarmulke, maybe wearing a Star of David, they would block them from moving. They would, passively link arms, block them. Is that behavior, which again, I'll ask the same question, can it be limited? Should it be limited?
It is not behavior protected by the First Amendment. The campus can have, I'm sure does have rules that prohibit obstructing paths or obstructing movement on campus. There is no First Amendment right of those who are obstructing individuals, and especially if they're doing so on the basis of religion. The campus has ethnicity. The campus has the obligation to take action. Now, what they should do becomes a much harder question. My instinct is it's one thing to say you can, for a period of time, occupy an area. It's quite different if the students are harassing somebody on the basis of religion, ethnicity. That's never tolerable.
So, and you're raising, Erwin, one fine point. A Pew study a couple of years ago indicated that Israel was either critical or important to the religious identity of 83% of Jews. Given that, can one say, I am not saying anything about your religion, I'm talking about Israel. So my attack against you is that you are a supporter of Israel, not because of your Jewish religion. Is that a distinction that works?
It's an enormously difficult distinction, precisely because of the statistics you mentioned. Criticizing Israel's policies, that's not anti-Semitic. Criticizing the policies of the United States government is not being anti-American. And so I think it's completely appropriate for people to criticize what Israel's doing in Gaza, or more generally, Benjamin Netanyahu's policy. On the other hand, we can say that there are certain things that are anti-Semitic that, however we define it, it's crossed the line. I've heard too many instances of swastikas being painted on doors, dormitory rooms of Jewish students. Doesn't matter how you define anti-Semitism, that's it. Or mezuzahs being taken down from doorposts in dormitories from Jewish students. Or Jewish students walking across campus, if they have a yarmulke or they're wearing a Star of David, being harassed. Or a poster that was put up of me on law school bulletin boards and online that showed me holding a bloody knife and fork with blood around my lips. That's the horrible anti-Semitic trope of blood libel. So however we define anti-Semitism, that's crossed the line. Now you get to the hard question. Are those who call for the end of Israel and want one Palestinian state anti-Semitic? And I've thought a great deal about that, and I've concluded, at least since October 7th, those who call for the end of Israel, it is a form of anti-Semitism, in part for the statistics that you mentioned, but also in part, how would that be accomplished? How would we ever get to the point where there isn't in Israel? I think that Jews do have the right to have a nation. And I think those who call for the elimination of the Jewish state are engaged in anti-Semitism.
And is there an issue there of a double standard? If somebody does not protest when Syria gasses 200,000 people, but calls for the elimination of Israel on grounds that are not even that strong. Is a double standard a feature of anti-Semitic activity?
I don't believe that somebody has to condemn all wrongdoing in order to condemn some wrongdoing. I think there is often a double standard applied to Israel, but I'll confess I apply a double standard to Israel. I want Israel to meet the highest norms of international human rights. I want them to meet the highest norms of humanitarianism. And so in that sense, if it's a double standard, I'll embrace it as a strong supporter of Israel. But I think that the calls to eliminate Israel, and that's now what we're hearing, I'll regard that as anti-Semitic.
Erwin, I am 2 miles from Cal Berkeley's campus as we sit, and you're on it. First, there is a mythology, at least, you can tell me whether it's true or not, that Cal's campus in particular is a dangerous or hostile one towards Jews. Do you have any comment to that?
Overall, that's nonsense. I've been on the campus for 7 years. I'm in constant contact with Jewish students, both the Jewish Law Students Organization and individual Jewish students. I walk across the campus many times a week going to meetings. I would say prior to October 7th, and especially prior to the last month, the blatant anti-Semitic incidents are rare. I don't think it's a campus that's all hostile to students. But I think after October 7th, and especially in recent weeks, that the anti-Israel protests that are not inherently anti-Semitic and criticizing Israel's policies or Israel have often included blatantly anti-Semitic rhetoric.
One of the things that I think has been pointed to as an ameliorative towards with regard to anti-Jewish activity on campus is the Institute for Jewish Law and Israel Studies in your law school. Can you tell us a little bit about that group and what they do?
I'm very proud that we're the home of the Diller Institute on Jewish and Israel Studies. A law faculty member, Kenneth Bamberger, is co-chair with the political science professor, Ron Hassner, and they do terrific programs, bringing speakers to address a whole range of issues concerning Israel and Jewish law.
And I'm noticing that those speakers include Arab Israelis who talk about the state of treatment of Arab Israelis and folks who one would not be able to point to as strong supporters of Netanyahu and his policies. So it looks like it's a fairly broad-ranging resource that institute brings as well.
Very much so. And it's a great resource, not just for the law school, but for the entire Berkeley campus.
And I think maybe nationally, if anybody has a chance to look at the website for the Diller Institute for Jewish Law and Israel Studies, there's a link to probably 40 lectures that have been given over the last couple of years that I really commend to our audience out there, and I join in congratulating you about all of the beneficial things that program does. 200 plus major law firms, Erwin, have written to law schools across the country. I have to imagine you've gotten one of these letters as dean of Berkeley's law school, asking law schools to stand up to anti-Semitism and suggesting that they won't hire law students who engage in hate speech. So is that a proper role for law firms to play? There are some people who suggest that law firms are engaging in censorship or limiting free speech within their ranks. Do you have a reaction to that?
I'm committed to helping all of our students get jobs, whatever their ideology, whatever their views with regard to the Middle East. Law firms get to choose who to hire and not hire, so long as, of course, not discriminating based on race or sex or religion or national origin. I can relate a couple of instances of law firms that withdrew offers after they saw students' social media posts. That's the right of the law firm to do. I tell the law students on the first day of law school at orientation that they're becoming professionals and that they should be mindful of what they put on social media, that I can't protect them from the consequences of what they put on social media. I can't protect them from the consequences of their advocacy. And I certainly understand a law firm saying to me, we looked at this student's social media posts, and this isn't someone that we want our clients to be working with, or we don't think our clients would be favorably inclined if they saw those social media posts. I say to the students, I'm not trying to censor your speech, but understand that your speech has consequences, and the law school is not going to be able to protect you from those consequences.
Now, kind of going to the huge question, it's I think it's hard to ask about what the cause is of any rise in anti-Semitism because it's been so pervasive for millennia, and I kind of think to look for rationale behind an irrational hatred is a little bit self-defeating. But even before October 7th, the ADL was showing a rise of about 300% in anti-Semitic activity and behaviors in the United States. Do you have a sense as to what is fueling this rise of anti-Semitism in America today?
I think it's a complicated story. Initially, we saw this on the right. I think there's always been anti-Semitism under the surface, but white supremacist organizations were much more willing to express anti-Semitism. I'll give you an example. I've been writing op-ed pieces for 40 years. It's only in the last 8 years or so that when I have an op-ed on something totally unrelated to these issues, let's say an op-ed about gun rights or an op-ed that deals with an issue of separation of powers, my critics will write to me and do so pointing to my religion and making it anti-Semitic. In fact, Nick Goldberg, in a column in the Los Angeles Times, wrote about the tremendous increase in what he received as anti-Semitic messages. Now what we see on the left is that often anti-Israel sentiment gets expressed as anti-Semitism. Again, most criticism of Israel's policy or Israel isn't, but we're certainly seeing much more. I mean, there's almost this notion that Israel is a Jewish state, Israel is undesirable, therefore making aspersions on Jews. And that's what we're seeing too. So we're hearing it from the left and the right. And it's a very frightening thing. I have seen more anti-Semitism, we say, since October 7th than I could otherwise have said to see in my adult life. I saw it as a child, but I thought it had vanished, but I'm sure they're under the surface.
No, I used to think that what fuels this is ignorance and lack of information. And now I'm thinking that we have so much information, including so much misinformation, that people can find a source for anything negative they want to think about in terms of Jews. And so it's the expansion of information that has really fueled a lot of this.
Well, the web can be a source of hate. Social media can certainly spread hatred, and it does.
So if have you given thought to what can be done in order to blunt this rise of anti-Semitism? I know that this, you've got a very huge scope of expertise, and this might even extend beyond that.
Yes. I don't have good solutions to it. I think that the ADL does a wonderful job in programs to combat anti-Semitism. I think we need to include in all of the anti-bias and anti-hate trainings that are so common anti-Semitism among what we're trying to prevent. I'm hopeful that when peace comes to Gaza, and hopefully it will come very soon, that will lessen this wave of protests and lessen the tinge of anti-Semitism that sometimes is there.
You know, another actually an observation that was made at a speech at your institute a couple of weeks ago suggested that Jews are greatly supportive of American policies, and when the attack on American policies was from the right, attacks against Jews came from the right. At this point, as Jews are supporting American ideals, and there is a disenchantment with America on the left, it's leading to anti-Semitism from the left, and the Jewish community is not very good about disassociating from American values. So I thought that was a very interesting observation that was made.
I agree.
So let me ask this: if you had the ability to say, here is my solution for resolving these issues on campus, because I know that you've been in Berkeley, in Irvine, in Chapel Hill, at UCLA, and other places. What, if anything, is your formula for what should be done on campus?
I think campuses need to have clear free speech policies. They need to express unequivocally and emphatically that all ideas and views can be expressed. There should be clear time, place, manner restrictions for when and where there can be speech, and if necessary, punishment of those who violate those time, place, manner restrictions with regard to speech. That campuses should have clear non-disruption policies that prevent disruption of activities on campus. And I think if there are clear policies, the sort that I described, campuses will be much better prepared to deal with speech issues.
You know, I don't know if you saw the quote from Gavin Newsom today, who said, anybody who engaged in illegal behavior on the UCLA campus should be held accountable, including through criminal prosecution, suspension, or expulsion. The right to free speech does not extend to inciting violence, vandalism, or lawlessness on campus, said the governor. So hopefully that's something that's clear enough.
I totally and wholeheartedly agree.
Erwin, thank you so much for spending this half hour with us. I knew that we would run out of time before we ran out of really interesting topics. It's always a pleasure to be talking to you. I know it's been a pleasure for our audience and members of the audience. If you're interested in pursuing the issues that we have been looking at today, please give some thought to the American Bar Association section on civil rights and social justice, and we'll see you at another chair chat. Thank you very much.
Thank you for having me.
Thank you.